So one of the interesting things of the opinion about the opinion in Windsor is that Justice Kennedy mentioned a standard called careful consideration. And so this standard seems to be a new standard, a heightened standard above the what rational basis standard that's normally used for most laws in order to determine whether there's any kind of unusual animus or inappropriate animus or motivation for discrimination. And this has or could have a large impact on future cases with regard to persons who bring discriminatory cases under different laws because of sexual orientation. So if they can use the language in Windsor to set forth that they are actually part of a protected class or a suspect class, then that would mean that the court would need to review them using heightened scrutiny. And so heightened scrutiny is usually used in cases where there's racial animus or animus based on gender. And so that would be a step in a positive direction as far as the LGBT community with regard to having their cases reviewed under with a higher scrutiny.
So could that affect like cases on employment discrimination or
Yes.
housing discrimination?
Yes,
Oh, okay.
definitely. So it may be that the Windsor case is the foundation for moving lesbians and gays into a suspect class, and actually at some point the court ruling on whether or not they should have heightened scrutiny with regard to any federal law that impacts them in a discriminatory way.
And what groups are considered classes in that?
So classes would be race, national origin, ethnicity, gender, disability under the American Disability Act. So Native Americans, those would qualify as suspect classes.
Okay. So right now, a lot of organizations have their own non-discrimination policies. This would kind of make it so that they're all required to include that in non-discrimination policy. I mean,
well, it might in the future. A lot of organizations do have a non-discrimination policy, and they include sexual orientation. However, Title VII does not include sexual orientation. So, a person who was discriminated on the basis of sexual orientation couldn't bring a suit under the Equal Employment Opportunity Act with regard to that discrimination because it's not covered. They're not covered. So it may be that the language in Windsor lays the foundation for future opinions of the court to be ruled upon with regard to elevating the status of sexual orientation.